10,
9,
8, 7,
6, 5,
4,
3,
2, 1.
Welcome to Secrets of Surviving Alienation. And as we wind down what has been a really traumatic year for literally everyone globally, we're going to take some time today to remind ourselves of how lucky we actually really are. And every single day, people wake up in the nightmare of family destruction, reorganization, dissolution, divorce, realignment, call it what you will. It's hard enough until you start adding into the mix family courts, lawyers whose entire livelihoods and professional reputations are predicated upon the monies with which they are able to successfully extract from their clients and this process. It has become a $50 billion a year industry. And that's a statistic that's staggering when you consider that casino income across the United States is less than $50 billion a year as an industry. So all of a sudden, when you look at family courts are now more lucrative than casinos, one begins to reimagine what it is to roll the dice every time you set your foot upon the courthouse steps and entrust what you believe is the most important thing in your life to people who share your interest. And, well, commitment to the children involved in every situation, especially when they're your own. You realize that it's a rigged game. The dice are loaded. The house has an advantage that you don't know exists until you step into that casino of legality, let's call it. And if you have the right croupier, if you have the right dealer, if you have the right casino host, you are so much more likely to win than not. But even then, you have to remember the house always wins. And in this case, who's the house? Is it merely the party with the most money, or is the house the actual system itself? And how do you, as a conventioneer with a pocket full of $100 bills, hoping to get lucky and believing that everything has a legitimate chance of winning? Say you're a kid going to a carnival with a quarter that you believe you can transform into a giant teddy bear just by tossing a ball through a ring or playing another game of chance. You don't know that that's the case because at the cornerstone of our very culture, of our very nation, are documents and systems that suggest that the things with the most integrity of all are those things upon which our culture and system of laws and democracy are built. The three equal branches of our government, including the legislature, who write the laws and make the laws, the executive branch, and most powerfully, and perhaps those with the most credibility up until this point, the judiciary. We have an extraordinary experience today to recalibrate our perspective. And before you think, oh, I won't go to the casino, I won't go to the carnival, I won't play those games of chance, are there things that you can do that will actually equalize and make more fair that opportunity with which you walk into these places with? Is it really as rigged as we think? Are there things that can be done? Today, Alexander C. Baker, JD, is a legal expert and president and founder of the Postmodern Justice Media Project. This is a nonprofit that's dedicated to providing information, news, educational services to all kinds of people who are merely just devastated by family breakups, and especially the devastation that's caused by the corruption that exists in family court systems, Alex is himself a victim of parental alienation syndrome, and sadly, he hasn't spoken to either of his two daughters in over 4 years. That is a heartbreak for any parent. And for those of you who have woken up today in this first day of this journey, we are not here to sadden you or to tell you about this crooked system. We are here to give you hope and help you survive. And towards that end, I am extraordinarily honored. It's a privilege to have the founder of the Postmodern Justice Media Project with us, Alex Baker. Welcome.
Hey, thanks for having me on. It's really a pleasure to be here. Thanks.
Let's first of all talk about the Postmodern Justice Media Project. Those are all words I recognize on their own. What together do they mean?
Well, postmodernism is this philosophy, or really anti-philosophy, that seems to have swept through academia. And it holds that there's no such thing as truth or objective reality or anything. All we really have are competing narratives. Instead of the truth, there's your truth and my truth, but there's really, that's really all we have. I think most reasonable people just find this to be nonsense. And it appears that our court system has picked up on this. And if you think about what witness testimony is supposed to be based on, you swear an oath to do what? To tell the truth, the whole truth, and nothing but the truth. And the system, as I find it, as I experience it, seems to be have bought into this postmodernist notion that there's really no truth other than whatever a judge wants to make up on the spot. And in the legal context, it seems like essentially there is no law. We just rather just seem to have this system of power that exists. So I founded this nonprofit, naming it Postmodern Justice, to try to do something. First, to try to make people aware of just what's going on. I, like so many others, used to just not excel when people would come to me and try to tell me about their horrible divorce and how corrupt the system was, or how it just didn't make any sense. I didn't necessarily buy into it, until it happened to me, and in the meantime, I was going through law school. So, and I've graduated from law school, and I have a Juris Doctorate now. So I think I have the expertise and the credential to say that I know the difference between a judge's ruling that is just something that I don't like versus a judge's ruling that is just out and out illegal and it's just and unconstitutional. So I'm of the philosophy that that this overall problem, and the parental alienation, this horrible destruction of families and everything that's going on, it can be solved. And I do want to leave us with a message of hope today, but I think it's only going to be solved with a simultaneous effort in both courts of law and the court of public opinion. And so I hope that Postmodern Justice Media Project, which is at pmjmp.org, will become the go-to alternative news and information source for exactly this field of study that we're trying to take on. So that's my idea.
One of the things that we've had guests speak about before is that in the system that you describe as postmodern, that's a caveat, a sort of carte blanche that lets participants have it both ways. And it's unusual, but it's becoming more common to find judges want it both ways. Litigating parties want it both ways. And if it's the case, let's go all the way back to the Constitution. Is the Constitution just one version of the truth? Or is it open to interpretation as well?
Well, it's clearly open to interpretation. I don't think it ought to be. Now, there's some parts of the Constitution that seem really clear, but there's lots of parts of the Constitution that can be and have been interpreted many, many times. There's all sorts of things that the federal government is now doing and now involved in that once upon a time were considered to be unconstitutional. So really, I mean, if you think about all these Supreme Court decisions that have come down 5-4, right? Well, if the most learned justices in all the land can't even agree between the 9 of them what the Constitution actually means, well, then how are just little old people like you and I supposed to even know what it actually means? But I think the best part of the Constitution is the Bill of Rights, which interestingly was not part of the original Constitution. The original Constitution, as it was drafted in 1789, didn't even have the word rights in there. It was all about power and establishing the power of the federal government. But a couple years later, I think they were getting some pressure from somewhere and think, maybe we ought to put some stuff in there about what rights the people actually have. And so the Bill of Rights and then the first, and the amendments to the Constitution do indeed talk about what our rights are. To me, when you say that Congress shall make no law infringing the freedom of speech, that to me is pretty clear cut. But I will tell you that here in 2020, almost 2021, I'm very troubled about freedom of speech and the First Amendment, and in no small part because of what these family courts are getting away with. There are these restraining orders now that just like tell people that they can't even talk to their own children, right? It's very common in California anyway, for judges to just order the parties, don't talk to your children about this divorce, and it's like, my goodness, there are entire books written on how to talk to your children about a divorce, right? And, I'm under a restraining order that says that I'm not allowed to publish documents obtained in discovery. Right. Well, that's, all of the Supreme Court cases in the past have said that this is what's called an impermissible prior restraint. They're not allowed to put a gag order on your speech unless they specifically identify what words that you're not allowed to say, and further identify those as what's called unprotected speech, which is something like a true threat, or obscenity, some very narrowly defined things that is not protected by free speech. But they seem to have now just completely thrown that out the window, and it's pretty troubling, I got to say.
One of the things I hear you say, one of the things we've seen in reading on your website, which is pmjmp.org, I'm struck by the notion that it's as if family courts are permitted to operate outside the purview of the U.S. Constitution. So imagine the federal Constitution governs everything except the really most local family courts. How is it that family courts have been successful in evading the constitutionality of their actions?
Yeah.
Or the unconstitutionality of their actions?
It's I think it was set up outside the Constitution from the get-go. So two of the most important amendments in the Constitution are the 6th and 7th, which guarantee the right to a jury trial. 6th Amendment, jury trial and other stuff in a criminal case. 7th Amendment, jury trial in a civil case. In the system of law that we inherited from England, which is good, it's a common law system that really, it was really a grassroots sort of bottom-up phenomenon. It was not really imposed from the top down. in that system, judges were never supposed to decide cases, right? Juries decide the case. The jury is the trier of fact. The judge is only the trier of the law. The judge was only supposed to be there to make sure that a fair proceeding was taking place, and that's it. But they, I believe, beginning more than 100 years ago, started setting up probate courts, and then family courts were modeled very much on that same model. And they just said, well, this is a judge trial. This is not a jury trial. And they just, as far as I can tell, they made that up. Now, I've heard somewhere, I don't see anything in the law, but I've heard that they consider themselves to be a court of equity, right? Which is just, it's not true. So in the old system, there used to be courts of law and courts of equity. So a court of equity is where you go if you have no remedy in a court of law. And a court of equity is just simply saying, what happened to me is unfair. And if you've gone to the legal system and you've tried all of that and that didn't work, you can still make an equitable argument, just saying, you know, Your Honor, this judge of a court of equity, it was unfair what happened to me. And you can argue that. And that indeed is only a judge trial. It's like a last resort. In our system, they put those two courts together. So we have courts of law and courts of equity all in one. That's still okay. And it's still the rule that before you argue something in equity, you have to exhaust all your legal remedies first, all your remedies at law. So all of that is fine. So, but they just made up a thing saying, well, family court is a court of equity, therefore you don't get a jury. And it's like, well, no, you know, there are all kinds of laws and legal remedies. That's what all these statutes are, right? And it's all about the money, right? So any money judgment is by definition a civil remedy, a legal remedy. So it's just nonsense to say that these are not courts of law, right? And the other thing that's an issue in family courts are like the custody and the welfare of children, which that's actually getting into criminal law, because if you can take somebody's child away from them, that's a criminal punishment. And you have a fundamental right to liberty, which includes raising your children. And so for them to take that away, that's a criminal punishment.
And hasn't it been ruled upon that in fact it's a constitutional right to raise your children without interference?
Absolutely, yeah. So there is a one of the landmark cases on that is called Troxel versus Granville, I believe it is. And they find that fundamental right in liberty, right? So the due process clause in both the 5th and 14th Amendments says that they cannot deprive you of life, liberty, property without due process. And inside that liberty has been found that you have a right to family unity, which is a right to raise your child. And there are several other cases on that too. Absolutely, unambiguously have said that is a fundamental constitutional right that cannot be taken away without due process.
And how has the current climate in family courts across the country taken that and interpreted it to be the mechanism or the tool by which one parent excludes the other parent from the life of the child?
I mean, I think it just starts with they made up a whole set of rules where due process just doesn't even enter into it. You know, this, because there are criminal penalties possibly at stake, this should absolutely be a jury trial, and there should be, a right to an attorney. There should be a right to confront your accuser. There should be all of these rights, And so, for example, anytime there is, let's say, a temporary custody order, right? It's very common in family court. I know this happened to me. to on like almost no notice, almost no hearing whatsoever, to grant temporary custody to one parent, and then either no visitation or only monitored visitation to the other parent. And this is absolutely a destruction of the fundamental right to parent without due process. You know, they say, you know, well, you know, you can still, it's only temporary. They want you to fight, of course, right? This is the business they're in. Come to family court and fight for your parental rights back. But this is so the cart before the horse. It's like, no, it's like, you don't get to like take my kid and then make me fight for my rights back. It's like, you have to prove in a court of law that I did something wrong first, you know, and then maybe you can take my kid away. But
and that sounds like a nice, high, reasonable bar to protect everybody, when in fact that's not the bar. The bar seems to be as low as possible, and the place where the bar seems the lowest is at the initiation of a family court action, where you can simultaneously obtain a temporary order of protection ex parte without any notice at all, and the presumptions flow like a waterfall from there. Once you have been excluded from your home, excluded from your child, it's the common practice today, it seems.
Absolutely. So these protective orders or restraining orders, DVROs, and in California we have this Domestic Violence Prevention Act, the DVPA, which at first blush seems like a good and necessary thing. Who wouldn't want to prevent domestic violence, right? And domestic violence is a thing. Absolutely. And there are people who are violent, and there are other people who are in very dangerous and unfortunate situations who I think we would all like to protect. But they've made the language of the DVPA, and I think there are similar laws all across the Western world, really. They've made the language so broad, so all-encompassing, that they can literally find somebody to be in need of a protective order for nothing, for absolutely nothing. In California, there's a whole list of things that are restrainable, and the beginning of the list is all good. It's hitting and striking and battering and sexual battery and all this, and all that's fine. That is restrainable conduct. But then along in the list comes disturbing the peace. And then there's been case law that finds that what does disturbing the peace mean? Well, it means any conduct that destroys the mental or emotional calm of the other person. And if you'll notice, that kind of language does not say anything about the conduct of the accused. It says only about the mental state of the accuser. Well, I mean, destroying the mental or emotional calm, that could mean anything from a credible threat of imminent death, right? All the way down to like, you voted for the wrong political candidate, or you don't approve of my birth control, or you don't like the slogan on my t-shirt. Okay, those are all things that could upset the peace of mind of somebody else. Yet all three of those are things that the Supreme Court has found are protected activity. I mean, voting for who you want to vote for, using contraception, having a slogan on your t-shirt, and exercising your free speech. So we just see that there's this very, very obvious constitutional conflict. And so far, in my experience, these restraining orders have been winning out over what used to be our rights.
Is it fair to say that the nuclear device that the order of protection once was is now as commonplace as punctuation in the commencement of any family litigation?
It's just, it's become family law 101. It is such a a powerful strategic device. And I have to, resign myself to the fact that a lot of what we talk about can be used by those who would do wrong, as a how-to manual, right? But we've started calling these restraining orders the silver bullet, and with very good reason. It is just family law 101 to hit the other person with one of these restraining orders right near the beginning, to make them, it's the kind of thing that you don't see coming. You're blindsided by it. And it is both financially and emotionally devastating if you're a person who knows that, you're not a perfect person, but you never did anything to deserve a restraining order. I know I didn't. I've never done anything remotely violent in my entire life, period, end of story, right? But it just becomes such a devastating thing. I mean, I know people who formerly, I know this one friend of mine, I'll just call him Michael. He is under one of these nonsense restraining orders. He's a practicing attorney for 30 years with 3 kids that he loves with all his heart. He is like so devastated. He can barely, get out of bed in the morning. He hasn't worked in close to 3 years. And just over and over and over again. I know so many of these stories, and it's, but it puts the person at such a disadvantage that the other side, these attorneys, these family law shark attorneys, can just use that then as strategy, because they know that you'll do anything to get your kids back, like give up the rights to your house, for example, like make concessions on these other things. And so it is so sad and so unfortunate and damaging enough to the parents, to say nothing of how damaging it is to these children who are used as both a weapon and a shield. It's really got to stop. And I believe that that we can put a stop to it. It's not going to be easy, but I know there's a lot of people working on this project. So
and we have to say, we've heard this story repeatedly from guests, colleagues, and experts alike. So please know we empathize with your situation as much as anyone can. And it's also challenging because these orders of protection are court orders from a legitimate judge. And on the surface, to the third party in the outside world, if you said, we have a restraining order against Alex, the assumption and presumption becomes, well, he must have done something for a judge to make a real order. I mean, that just can't happen without anything. In fact, it does. It's also really difficult because the opposing parties that go and get these wave them then like a suffragette banner of victimhood, when in fact they've perpetrated the entire action to begin with.
Yeah, it's in California, you get one of these family law restraining orders, which they pass them out like lollipops, and then immediately your name goes into the klutz database, which is the long. It's an acronym for something. It's the database of criminals, essentially.
It affects your rights to travel. It affects your rights to work.
All of that, anything that has any kind of a background check, it just pops up on there. And all it shows is that you're restrained from coming within 100 yards of the other person. You have a no contact order. And then there's other, no firearms order. And then there's can be specific things that are written in there also. But you're absolutely right. Most people who have not been through this, exactly as you say, well, you must have done something. We live in the good old US of A, and you're not going to get a restraining order unless you need it. I mean, I can tell you story after story after story of one guy they denied the temporary order, or no, they granted the temporary order, and ordered him only to contact his ex-wife through Talking Parents, right? This online website where you can communicate, and only about arranging child visitation. And this guy committed the heinous crime of informing his ex-wife that grandpa was in the hospital and it might be a good time for the kids to have a Zoom conference with grandpa in the hospital because maybe he's not doing so well right now. And because he reached, and that was it, the judge ultimately found none of the original allegations that caused the temporary order. None of them were true, but that one thing that he sent a message that was arguably not about visitation, but it was about informing them that grandpa was in the hospital. That was his domestic violence. I mean, in my case, my only domestic violence was that I sued my ex-wife for copyright infringement. I won the lawsuit. It was upheld on appeal, but I had the unmitigated audacity to make an internet blog about it and to talk about it and post the judge's ruling about it. And this upset my ex-wife's peace of mind, which I'll stipulate that litigation can be stressful, but that was the finding. And they literally said it doesn't matter whether my litigation has merit or not. All that matters is the effect that it has on my ex. And it's exactly what the judge said. And I mean, I could go on, but it's really, and it's especially tough because there really is domestic violence. And one of my concerns is that we've now, I think, set back the clock 50 years on this whole issue. I think once upon a time, we were a little, we were not as evolved as we could be. And there was a feeling 50 years ago or more where if a man, let's say, really was beating up on his wife and really was, threatening her and abusing her in that way, there was an attitude of, well, maybe she just didn't listen. A man's got to kind of, put his woman in her place, or right. And that horrible attitude, there was something to address. And one of my concerns with this is that now that they've made these nonsense restraining orders about nothing, there might be a danger of returning to that, because you look at my example and yours and so many others, right? There might once again get to be this problem where, oh, it's a family law restraining order. That just doesn't mean anything. Even when in that case where they really did need a restraining order, right? So the whole thing is just a mess. It's just really, really a mess.
You could make the argument that if a court can't distinguish between a legitimate threat to the parties involved from a specious threat that has motivating factors of strategic advantage in litigation tactics at its core versus genuine harm and threat of violence or other harm. If a court can't distinguish between the real ones and the bogus ones, how can we trust family courts with the really important decisions? Because that, to me, sounds like a really important decision. Doesn't the very fact that they've squandered their credibility on the orders of protection throw the whole thing into suspicion?
I hope so. I think that is, of course, and it's simply a question of communicating that to those who have not had it happen to them. Everyone who's had it happen to them already understands this. We all had to learn the hard way, so it's not news. But I think the challenge now is to get this across to the greater public, number one, that is the way this is. We now have a system that lacks any credibility whatsoever. And two, why that matters, why due process matters. And I think it absolutely does matter. And I think it is going to affect everyone. And it has affected so many directly already, but it has the potential to just affect everyone. And so I think once again, we have to, that's our challenge to get this across. So really, that it is so and why it matters.
You are listening to Secrets to Surviving Alienation. We are privileged today to have as our guest Alexander C. Baker, JD. He's a legal expert and president and founder of the Postmodern Justice Media Project, a nonprofit dedicated to providing news, information, and educational services to people who are devastated by family breakups, divorce, dissolutions, and other devastating effects caused by the corruption that exists in the family court system. Alex is also a victim of parental alienation syndrome. Sadly, he has not spoken to either of his two daughters in over 4 years. We're thrilled to have you here because as a forum for people who are literally finding themselves in your shoes without the JD, the Juris Doctorate after your name, and without those resources that enables you to proceed with and prevail, hopefully, with. We're here to give people immediate, actionable, informational resources to wake up as quickly as possible to where they now are at. And in this conversation about, and we're literally still on square one talking about the initiating stages of these family actions and these temporary orders of protection, it gives us the chance to ask about deceitfulness, misrepresentations, and outright lying that starts at the very beginning of most family actions that find themselves in court. My understanding is only 5% of divorces end up in litigation. But of that number, something close to 90% become high conflict. Can you talk a little bit about the role that being untruthful has in that cluster and that bundle?
Well, I think it's when you say untruthful, so it is the truth. It is the case that we swear an oath to tell the truth, the whole truth, and nothing but the truth. But here's what maybe you don't know. We have this curious little legal doctrine that we inherited from medieval England that has made it onto my top 10 list of most corrupt laws of all time. I believe it comes in at number 2. You can find that special report at postmodernjusticemediaproject.org. And that is the litigation privilege, which really they ought to rename it what it really is, which is the perjury privilege. The litigation privilege holds that essentially you are not allowed to sue somebody because of what they said in court, not even if it's false, not even if it's defamatory, not even if it cost you $1 million and you can prove it, not even if it's perjury, right? That is a false statement under oath about a material issue. It is what's called absolutely privileged, and the lawyers all know this, and so it's absolutely no surprise to me, or in my view, to any thinking person. It is no surprise that the family court system has become just a cesspool of lies. I literally, this is not an exaggeration. I have this tremendous experience in both civil court and in family court, in both the state and federal, at the trial court, appeal court level. I have never experienced even a single case where I thought both sides were actually telling the truth, and it was just about trying to get to a reasonable decision. Never.
Do most judges now assume everyone is lying?
Yeah, I mean, it's in most cases it's so obvious, when people tell these stories that just cannot possibly be true, and they let it go, or they just have a willful blindness, or they refuse to or they allow, they refuse to allow the obvious questions, or they refuse to admit the documents that would show things one way, or
they refuse to allow the perjury to diminish the credibility of one of the parties.
Right. Exactly.
How is that even possible?
It's, so, I mean, the magic word is discretion, right? So they have written literally into the rules, these judges who are acting as judge and jury, which is wrong from the get-go, but they give them such broad discretion to find fact, right? So it's up to the judge to decide who do they find credible and who is not credible. And it's literally
so
just
you started out today by talking about courts and fairness. I think we've gotten very far away from that concept.
I mean, if we were ever there, and it does seem that I think maybe to some extent, maybe there has always been at least the possibility of some shady business that might go on in court. But it seems like in the last few years, for whatever reasons, it's just gotten in your face about it. I mean, judges will do things that are just knowingly disobeying the law, or just knowingly giving all the money to one party, or all the property to one party in a divorce where the law says it's supposed to be 50-50, and just all these examples. And but
could it have anything to do with the President of the United States stating that he could go in the middle of Fifth Avenue and shoot a man and get away with it? Does that set a tone for the country, including the courts?
It might very well have. It might have set a tone, or it just might have been in reaction to the news that it's just an open season on our rights. I mean,
including the truth.
Yeah. I mean, we also have, former President Barack Obama openly declaring war on the First Amendment. I don't want to
get political. Let me ask you a different question.
I kind of don't. Yeah. So
let me ask you a different question. Does each American have a constitutional right to the truth?
I believe that they do. I think people have a constitutional right to due process. And I would, if I can inspire and help others out there to take actions, that's one of the things that we help people to do at PMJMP. So, I mean, I do want to spread a message of hope. First of all, with regard to children, children are resilient, and I have definitely heard stories of children, of the children of alienation situations, who grow up a little bit and who figure things out and come back to the alienated parent. So I do want to put out hope for all of those alienated parents out there.
This is a show called Secrets to Surviving Alienation. And when you agreed to come and educate us today, for which we're enormously grateful, you also agreed to share some of your own secrets, because as difficult as it is to go 4 years without communication with your own daughters, because of active parental alienation syndrome. You have, in fact, survived. And you are a testament to a kind of hopeful strength that we are hoping you can describe for us as examples of how anybody might be able to survive, and in surviving actually be prevailing. These situations are so painful, and I'm going to give you the floor and ask you about your own situation. How have you survived?
Well, if you would have talked to me 5 years ago, when this was really first coming down, I might have answered you. I might have said, "Well, I'm not so sure that I have survived." But I'm here today in 2020, and it's been a combination of a few things. Now, I will say that in my case, I had to, in a sense, process the loss of my children almost as one would a death, to grieve, to just go through this grieving process, while at the same time holding on to a hope that they're resilient and smart enough to figure out that this is really just a product of their what they see as their loyalty conflict, and that they had to buy into all the lies of this therapist and these and this restraining order and all this nonsense and all the lies they were told. So it's a combination of that. But then eventually it came to be finding purpose for myself. I have tried to now take my experience, what has happened to me, and then my knowledge that it's happened to so many millions of other people. And details are always different, but the bottom line is always the same. And to try to make something good out of it, which is change. And I know I have skills and smarts and credentials and experiences, and I have all of me that if I choose to, I can put this to work on this problem. I can't do it alone. And that's why I'm here, both here on your show and here with my nonprofit, and here doing what I'm doing. I try to encourage people. Maybe it's possible that you can mediate your way out. I know it, for anybody who probably is listening, it doesn't seem like this other unreasonable person will do that. But there are some strategies where you can actually get that person to that. That's one of the things that we try to teach. There are a lot of things in litigating your existing case that you can try to do. Well, we try to help with that. There's things like, you have certain rights, but here's one that I want to put out for your listeners. And this is at your trial court level. If you don't raise it, you waive it. And what that means is that if there's any way that your rights are being taken away from you, you need to argue that at the trial court level, in your family law proceeding or in your civil court proceeding, to then have that become an appealable issue that you can hopefully then get overturned. So we're helping people figure out how they can actually do that. In parental alienation, there's the role of expert witnesses, and they don't make it easy to understand the procedure of how to find an expert witness, how to designate an expert witness, how to get somebody who actually could bring this expert sort of gravitas to the situation. So we'll try to help with figure out how to do that. people can think of.
And I want to interrupt you there because
Sure.
I want you to clarify something on that point. If you don't raise it, you waive it. But there are lawyers on the other side who are actively swatting away your attempts to raise issues. And it seems counterintuitive to look at a system that proclaims itself a court of equity, where the pursuit is fairness, where almost every state statutory guideline says we are going to try and achieve some kind of reasonable fairness. On the books, that's what it says. In reality, we're talking about something very different, aren't we?
Yeah, I mean, there's so many. I mean, I could write a book about dirty lawyer tricks, and one of the most common ones is that they'll get you to argue the wrong side of your own case, right? And so, yeah, if you have an issue, you need to raise it. And, you know, most people go into these family law proceedings not even knowing how to get an issue in front of the judge. This is one of the most frustrating things, is you've got this whole story to tell. And every time you go into court, you want to tell the whole story. And then she did that and he did that and all of this stuff. But what you don't know is at any point in time, there's only one issue in front of the judge. And the judge is only going to take it one little thing at a time. And yeah, they want to make you feel bad about raising an issue, right? As if you're doing something wrong by doing so. And they might even do like they've done to me, which is declare you a vexatious litigant, which is if the restraining orders are the silver bullet, these vex litigant orders are the nuclear bomb. What
does that mean?
The vexatious litigant order?
Yes.
Right. So in many states like California, and a lot of them are following suit, they have a so-called vexatious litigant statute, which is supposed to stop vexatious litigation, meaning a person who files an improper, right, an unrepresented person, self-represented.
Meaning they don't have a lawyer.
Say what?
Meaning they don't have a lawyer. So it's a person with a lawyer on one side, a person without a lawyer on the other side.
Right. So it says that if you bring a bunch of lawsuits and you lose them all, and then you come right back to court and try to refile your same lawsuit again that you already lost, or you keep filing frivolous motions or meritless motions, or you're only filing stuff to harass or delay or to harass the other side. That's what's known as vexatious litigation, and that's a real thing. There have been people who do this. So they made a law that if they find you to be a vexatious litigant, they put this order on you. It's a type of an injunction that says you are now not allowed to file any new litigation without the permission of the court.
How common is this?
It's getting to be very, very common. I never even heard of it until it happened to me. And since then, several of the cases that I'm involved with, our clients have had these slapped on them. And
was this an article in the Journal of the Academy of Matrimonial Lawyers or some other kind of professional seminar at a professional development meeting?
Well, I don't know. Could be. Like, how does the word spread, you know?
Well, my question to you is, you talked about it's a statute. Somebody had to have a problem. If it's commonplace already, then you would go to the legislature and say, we need a law to solve this problem. Who goes to the legislature before you have a problem to solve? And maybe this was a problem. I don't think it ever really was a problem, because
there's ways that you can punish somebody for frivolous litigation. In fact, the whole idea of frivolous lawsuits, in my estimation, is a hoax put out by big defense. And I don't know if that's too far off the track, but there are these statutes, these vex litigant statutes, and just like domestic violence, right? There really is domestic violence, but they keep using these in these absolutely inappropriate ways to shut people down. Same thing with the vex litigant pre-filing orders. They're being used to shut down people. I think a big part of what's driving it is that only in fairly recent times have non-lawyers been able to go on the internet, to go to places like Postmodern Justice, for instance, to get up to speed on how to file motions, on how to defend yourself, so that you don't have to spend your life savings hiring a lawyer. I mean, how much do lawyers cost? Well, how much you got, right, is the real answer.
You get as much justice as you can afford. Hey, listen, we're running out of time, and I don't want that to happen. I've seen some of the Ask Alex podcasts and special report videos that you've done on postmodern justice. You talk about dirty lawyer tricks. What are some of those that people really need to watch out for?
Right. So a few of them we've already touched on, right? The nonsense restraining orders. Watch out for those, and understand that nowadays, just sending text messages, all kinds of things can be subject of those.
Is there a tactic to neutralize that?
I think the most important thing is just to be aware that it's out there. Just to know that there are speech-related restraining orders, and so if you're in a divorce situation, be very, very careful about what you say, what you email, and like that. So just know that it's out there, and really, really be careful about that.
In your view, are the courts biased against any particular groups more than others?
I used to think so. I used to think they were biased against men because child support often disfavors men, and custody often does. But I no longer think that. I have seen just as many women be screwed over, possibly for different reasons. But I now think that family court is an equal opportunity abuser.
I'm going to say that my answer to that question would be the court is biased against the people who don't have the resources.
100% agree. Absolutely. No question about it.
And if that's the case, there's no parity in the legal system.
And despite the law saying that they're supposed to be, right? The laws in California, anyway, explicitly says that if one person has all the money and can afford an attorney, they have to pay for an attorney for you. Either both sides have an attorney or neither. It's supposed to be that way. And I brought that motion in my case, and the judge just denied it, and it's crazy, But I think there are things, that we can do, and that is what we're doing. So again. I would, encourage people, go to pmjmp.org. And I also want to shout out to the Family Court Anti-Corruption Coalition, Family Court Anti-Corruption Coalition.com. All of that spelled out. That is a place where you can go get membership. There's hundreds and hundreds of people now in there, forming groups, projects, coalitions, all kinds of stuff going on there. So between those two, I really want to encourage you to look at those resources, because that's something that you can do. There are civil rights cases going on right now where we are challenging these officials who are doing these things. And I believe that these can absolutely be successful. There are some of these civil rights cases that have been successful in the past. We've
got about 10 seconds. I want to thank you, Alex C. Baker, JD. He is the founder and president of the Postmodern Justice Media Project, dedicated to providing news and educational services to people who are being devastated in the family court system. We barely scratched the surface of parental alienation today. Please promise you'll come back and visit with us so we can do a little bit more digging deep in that. Our Facebook feeds, everything's blowing up on us. People have a squillion questions. Will you come back and visit with us again, please?
I absolutely will. Everybody, there is hope. Okay, that's what I want to say. Peace. There is hope. This is tough, but I will absolutely come back. It's a tough mountain to climb, but not impossible. Hang in there.
And that
my
wraps us
greatest
up.
moments didn't come from my greatest moments. My greatest moments came from my greatest defeat.